Welcome to the deep dive. This is where we take complex stuff, break it down, and give you the essentials fast.
Especially with something like the U.S. patent system.
Yeah.
We're aiming to be your guides through the MPEP section by section.
Exactly. It's an ongoing series, making the Manual of Patent Examining Procedure accessible. We cover each section within each chapter. Really, it's for anyone dealing with U.S. patent law pros, students, exam takers.
And today we're jumping into Chapter 1200, which is all about appeal, specifically MPP section 1204.
Right, this section titled simply Notice of Appeal. So for this deep dive, our goal is to unpack the how and the when of kicking off an appeal to the PT, Patent Trial and Appeal Board, by filing this really critical notice.
It really is the starting point.
Yeah.
The formal gateway. Getting this right is just fundamental.
Okay, let's walk through that gateway then. What exactly is this Notice of Appeal according to Section 1204?
So basically, MPEP section 1204 lays out the guidebook, the instructions, for how you actually start an appeal to the PTT. It's your formal statement saying, hey, I disagree with the examiner's final decision, and I want the board to review it.
And that goes for both patent applicants during prosecution and patent owners in reexamination proceedings.
That's right. It covers both scenarios where someone's facing a rejection they want to fight at the board level. The ex parte bit just means it's mostly between you, the applicant or owner, and the patent office at this stage.
Got it. Okay, let's zero in on patent applicants first. What actually triggers their right to file this notice?
Okay, so for applicants, Section 1204 says you can file an appeal after any claim in the application has been rejected twice.
Twice rejected. Okay, seems simple enough. But there's a really important detail about where those rejections can happen, isn't there?
Yes, absolutely. And this is something you really need to watch. Those two rejections don't have to be in the same application you're currently working on. They can happen, as the MPP puts it, across related applications.
Ah, okay, that's a key strategic point. Can you give us the example to use?
Sure. So imagine a claim was rejected in a parent application. Then you file a continuation, present the same or similar claim, and it gets rejected again. Now, even if that's the first rejection in the continuation, because the claim itself has been rejected twice across these related cases.
You can file the notice of appeal from that continuation.
Exactly. You've met the two rejection requirement based on the claim's history.
Wow, okay, that's significant. That potentially saves a lot of back and forth in the continuing application if you already have that history. Huge time saver, potentially.
It is. It acknowledges the life of the claim beyond just one file. But there's a big but for applicants tied to this, a restriction.
Which is?
You absolutely cannot file a notice of appeal at the same time as you file a request for continued examination in RCE.
Ah, right.
The application has to be, officially under rejection. Filing an RCE means you want more examination from the examiner. An appeal means you want to stop examination and go to the board.
Makes sense. You're choosing one path or the other at that point. Can't do both simultaneously.
Now, shifting gears slightly, for patent owners involved in ex parte reexamination, the rule for when they can appeal is a bit different. It actually hinges on a specific date.
Oh, so for owners whose patents are already granted but are now being re-examined, the timing depends on when that re-examination started.
Exactly. If the ex parte reexamination was filed before November 29, 1999, going back a bit, the owner could appeal after a second rejection of a claim.
Okay, similar to the applicant rule then. And what about for re-examinations filed on or after that date?
The standard got higher. For those later filings, the patent owner has to wait for a final rejection before they can file that notice of appeal.
Ah, so a final rejection became the necessary trigger post-1999.
Interesting. Seems like a move towards maybe wanting a more complete record before things head up to the board in those cases.
That seems to be the likely rationale, yeah. Get the examiner's final word before escalating. Okay, so we know you can file. What about the how? Section 1204 gets into the procedures, deadlines, fees.
Yes, the nitty-gritty details. And fees are definitely part of it.
Let's talk costs. What fees are involved right at the start?
Well, there are generally two main ones tied to getting the appeal launched. First, there's the basic fee just for filing the notice of appeal itself. That's laid out in 37 CFR 41.20B1.
Okay, filing fee. Got it.
And then separate from that, there's another fee required later on. This one is for forwarding the appeal, actually sending the case file up to the board. That's under 37 CFR 41.20B4.
Right, so one fee to start the clock, another to actually move the case upstairs. And after filing the notice, you still have the main event, the appeal brief.
Correct. The appeal brief is where you lay out all your arguments. You have to file that within 2 months of filing the notice of appeal. and it needs to follow the rules in 37 CFR 41.37.
And the fee for that brief, I thought I saw something about a change there.
You did. And it's good news, relatively speaking. As of March 19, 2013, the specific fee for filing the appeal brief was actually reduced to $0.
Zero? Wow, that's unusual for the PTO. Does that make appealing significantly cheaper overall?
Well, it helps, but hold on. Section 1204 quickly points out that even though the brief filing fee is zero, other associated fees, like the notice fee we mentioned, the forwarding fee, and potentially fees for an oral hearing, if you request one, may still apply.
Ah, okay. So one specific fee went away, but the overall process still has costs. The notice fee, the forwarding fee, maybe hearing fees, it's not free.
Definitely not free.
Sure.
But you weigh those costs against, say, filing another RCE and continuing
Right.
prosecution. Right. It's a strategic choice.
Now, there's a really, really critical point in Section 1204 about what the notice of appeal actually covers and what happens if you don't follow through. Scope and waiver.
Yes, and this is probably one of the biggest procedural pitfalls if you're not careful. When you file that notice of appeal, the default assumption, legally, is that the appeal is presumed to cover all rejected claims.
All of them. So if the final rejection rejected, say, claims 1 through 10, just filing the notice means you're appealing the rejections for all 10.
That's the presumption.
Unless
you take specific action. The only way to not appeal certain rejected claims is to explicitly cancel them with an amendment. You typically do that before or with the appeal brief.
Okay, so you have to affirmatively remove them. What if you don't cancel them, but then you just forget or choose not to write arguments for some of them in your appeal brief?
That's where the waiver hammer falls. The MPP states clearly, failing to present arguments in the brief for all the claims you've technically appealed, well, it can result in the waiver of those arguments.
Waiver? That sounds bad. What does that practically mean?
It means you've essentially forfeited your right to argue about the patentability of those specific claims before the board. And crucially, the MPP notes this waiver may impact the applicant's rights in any subsequent judicial review.
Whoa. So if you later try to take the case to court, like the Federal Circuit, you might be completely barred from raising issues about those claims because you didn't argue them properly before the PTAB.
That's the risk. It's a classic use it or lose it scenario. For your arguments on each rejected claim you haven't canceled, you must preserve the objection by actually arguing it in the brief.
Man, that puts a huge burden on making sure that appeal brief is comprehensive for every single claim under appeal. You can't just focus on your favorites.
Absolutely critical. The source even mentions case law, like Hyatt v. Dudas, as an example, highlighting how important it is to preserve all your arguments at the board level. Don't waive anything unintentionally.
Okay, the section also seems to touch briefly on, administrative issues. What if the notice itself has problems, or you file it too soon?
Right. It mentions that if your notice of appeal is defective, maybe you missed some info or paid the wrong fee, there's a specific unit, the Patent Appeal Center, that handles those kinds of administrative snags.
Okay, so there's a process. And filing too early. Like, say you filed a response, and before the examiner even looks at it, you file an appeal notice.
Yeah, that's a no-go. The MPEP gives that example, filing before the office has even responded to your pending reply. That's premature. The section implies it won't be accepted or might be dismissed. The application needs to be properly under rejection before an appeal is ripe.
Makes sense. It also hints that Section 1204 connects to other things, like special programs.
It does. It briefly notes that this section covers special considerations for things like the pre-appeal brief conference pilot program. That's a whole other process, and also mentions rules about having interviews during the appeal timeline. It basically points you here as relevant context for how the notice filing interacts with those other procedures.
So let's pull it all together. The big takeaway from MPP, Section 1204.
It really cements its role as that critical procedural gateway we mentioned at the start. It's the non-negotiable first step if you want to challenge an examiner's rejection before the PT.
And it's not just a checkbox. It dictates when based on rejection history, the how regarding procedures and fees, and crucially, sets the scope of your appeal and the potential for waivers if you're not careful with your arguments.
Exactly. It's the rule book for starting that formal challenge correctly and staying compliant.
Before we wrap up this deep dive, we definitely want to give a special thank you to Mike Shepard. He's the creative director who organized this entire audio series.
And of course, the necessary disclaimer. This summary of the MPEP was put together using AI tools like ChatGPT and NotebookLM. It might have errors or leave things out. It's just for general educational info. It's absolutely not legal advice or a substitute for proper training. For the official word, you always need to consult the actual MPEP, a qualified instructor, or a registered patent practitioner.
Navigating the patent system really underscores how vital procedure and timing are.
Absolutely. And MPP Section 1204 is such a clear example of that, isn't it?
Yeah, it makes you think how this one document, the Notice of Appeal, which might seem like just filing a form, actually kicks off this whole intricate process. It sets deadlines, involves costs, and has these major implications for which arguments you even get to make later on.
It truly lays the foundation. Getting that initial step right, understanding its downstream effects, it's essential for anyone navigating the system.
Absolutely. Well, hopefully this deep dive sheds some light on that foundation. Keep exploring the MTP, seek good advice, and thanks for joining us. That's all for this deep dive.